Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning and welcome to the Court of Appeals morning session for January 21, I believe. I hope it's 21 anyway, to get rid of 20. But anyway, we want to thank all of you for agreeing to participate in this oral Zoom argument. It's the way that we've been able to keep the wheels of justice turning, so to speak, and we appreciate your participation. Momentarily, we'll start the oral argument, and we will conduct the oral argument just as if we were in the courtroom here in Jackson. And by that, I mean each side gets 15 minutes to make its oral argument. The appellant is able to reserve up to 5 minutes of rebuttal time, and I'm assuming the appellant's already discussed that with Mr. Hibner. Since we've got more than two appellees, I assume you two have agreed as to how you'll share time, and you can announce that when you begin your argument. Before we start, though, I want to introduce the panel for today. We have Judge Arnold Golden from Memphis, Judge Carmen McGee from Savannah. I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case then.
Helen Shaw as administrator for the estate of John Suttle versus Lawrence B. Gross, MD, et al.
All right, we will hear from the appellant.
Good morning, Your Honor. We will reserve no rebuttal time.
All right.
May it please the court.
Go right ahead.
I'm Chantel Suttle. I'm here on behalf of Ms. Helen Shaw, representing the estate for John Suttle. We're here today to ask respectfully that the court will reverse the decision of the trial court. The trial court found that Mrs. Shaw's case should be dismissed for failure to comply substantially with the pre-suit notice statute, specifically that the HIPAA authorization was not valid, was not in substantial compliance. In reliance on Williams versus Gateway Medical Center, the court found that the HIPAA, one, did not contain any description of the information to be disclosed or used, and two, that the form was signed by someone other than Mr. Suttle, and that there was no information concerning the individual or their authority to act. First, the form that was used by Ms. Suttle or Ms. Shaw, that is, in relaying or authorizing the medical information is different from the authorization used in Williams v. Gateway. The authorization in Williams v. Gateway actually instructed the individual to check boxes. It indicated, it asked yes or no questions, and then stated you may check the box of those that you want or as many as you want. The authorization, that is submitted by Ms. Shaw is significantly different than that. It states the type of information to be used or disclosed is as follows and include the date of service. And it specifically listed those things that were authorized to be disclosed. It did not say check the box, as is the one in Williams, where the provider or the individual given the authorization failed to check the box. The authorization by Ms. Shaw also included the dates of service as requested by the instructions on the authorization. The second issue was that the form was signed by someone other than the patient, and there was no description of that person. In Williams v. Gateway, there was no person and there was no instruction with the letter that indicated anything further regarding the release. The authorization provided by Ms. Shaw And the notice letter specifically showed that Ms. Shaw was basically the administrator of the estate. It indicated through specific instruction in that letter, which was pages long, that she's the administrator of the estate, that the order appointing Ms. Shaw as administrator is attached, that she is also the person giving or authorizing this notice, such that when the HIPAA authorization is viewed, the provider who's receiving that notice would know exactly who Ms. Shaw is, why she has signed, and that the court has given her authority so to do. So the HIPAA authorization, which is at this point the sole basis for the trial court's decision that Ms. Shaw's authorization or her case should fail, and the case on which the trial court relied are totally distinguishable. And so we're asking the court to so find. The trial court also found that because of those two alleged omissions, that the appellees were prejudiced in being able to obtain the records for the other providers. And we would submit, because those two cases, Williams v. Gateway and our case at bar, are distinguishable, as those two authorizations or the circumstances involved in those are totally different, that we're asking that the court find that there was no prejudice because there's no obstruction to the providers providing or being able to obtain the records, as Ms. Shaw did provide HIPAA authorizations that authorized Methodist to obtain its own records, and also authorized Methodist on a separate authorization to release the records to the other provider. So both defendants were able to obtain the records through the HIPAA authorizations that clearly tell them below are the things that are to be described, which means they should assume that, as is stated, the information below is what should be provided. It says the dates should be included. The dates were included May 14th through June 17th, 2014. And there was a signature of the person so authorizing, Helen Shaw, 6/4/15, with the notice attached indicating that Ms. Shaw is authorizing. She's done so at the request or at the authority of the court. And we're asking that Your Honor, in light of those circumstances, will reverse the decision of the court below and find that the HIPAA authorization substantially complies with TC 2926 121A2E, and that the instructions are different and do not say check any boxes. It just states that they're listed below, and so list. And the form, though signed by someone other than the patient, contains a letter that was attached there to indicating who this person is and by what authority.
Is it your position that the authorizations allowed Methodist and each of the other providers that were sent a notice to obtain the records from all of the other providers?
Your Honor, that is our position. However, the trial court.
Is that correct though? Is that a correct statement?
Well, we would say any of the others that were sent notice, we would say yes. And I think we would get into then some of the things that the trial court did not. The trial court did not address that issue. They specifically looked at the one, or the trial court specifically looked at the one authorization, and that was the one that was provided to Methodist, granted them authority to release the records to Dr. Gross, as those were the two only defendants. And though there was a list, like I said, the court never reached that and didn't get into any of that. So I would be going back speculating as to what the court was thinking in regards to that, whether she found that there was proper or improper, whether that occurred or didn't occur. And there was other counsel that actually argued that motion. And because that's not in the order and that's not a part of what she decided, she declined, then I would ask that I not be asked to speculate as to what she was thinking, Your Honor.
Thank you, Ms. Suttle.
And we rest.
All right. Thank you for your argument. We'll now hear from the appellees. Who's going first?
I will, Your Honor.
All right. Have you explained to or asked Mr. Hibner to set the clock accordingly, I assume?
Yes, Your Honor. I'll be arguing 10 minutes, and Mr. Welford would be arguing 5 minutes.
All right. You may proceed.
Thank you, Your Honor. My name is John Ryland. I'm a member of the Shelby County Bar, and I represent Dr. Lawrence Gross in this case. I'm going to address some of the arguments that the appellant's counsel has raised, and then I will move to some other arguments that I think are pertinent for this court's consideration. Number one, the appellant's argument trying to distinguish the medical authorization in the Williams versus Gateway Medical Center case is a distinction without a difference. The language of the release is not the critical component for this court's consideration nor the trial court's consideration. Both of the authorizations in this case and the medical authorization in the Williams case had the same defect. The core elements of any required HIPAA release require the release to identify and describe the records that are or information that's subject to disclosure in a specific and meaningful fashion. And that's the critical inquiry for this particular issue. And if you look at the authorization in the case at bar, you will see that that requirement was not even remotely met, just as it was not met in the Williams case. The instructions in the form are irrelevant. It is what the form allows for disclosure. And in this case, the authorization did not authorize the disclosure of anything. It had boxes just like the authorization in Williams, and just like Williams, none of the boxes were checked. The argument that, well, there were date ranges that were filled in the authorization of the case at bar, I submit as a red herring, because that applied to only two subsets of records, that being x-rays and lab reports. And it provided those date ranges, but it did not check the box to actually allow those records to be released. Furthermore, the statute here, TCA section 29-26-121, paren A, paren 2, paren E, provides that the release must authorize the release of complete medical records. Even if the appellate's argument had merit that this would allow the release of lab results and x-rays, that would in no sense of the word be compliant with the statute. And it didn't allow the release of lab reports or x-rays because none of the boxes were checked. So the appellant's effort to distinguish Williams is unavailing, I submit, and I submit that
Mr. Ryland, you have frozen, I believe.
Dismissal of this case and the dismissal.
Mr. Ryland.
Yes, sir.
I don't know if everybody else did, but I missed about the last 30 seconds of your argument. You froze there for a moment.
I apologize, Your Honor. Let me.
Not your fault. You just froze.
My point being that in both Williams and in the case at bar, the boxes were not checked, and there was no authorization to release any records. The inclusion of the date ranges only pertain to a very minor subset of the records in the statute. 121 paren E, paren 2, paren A, paren 2, paren E required their authorization to release complete medical records, and the authorization in the case at bar did not even remotely do that. The second argument that the plaintiff tries to make is that she argues that there was not a defect in the authorization relative to the disclosure of the authority of the signatory to sign on the patient's behalf. that authorization was executed after Mr. Suttle's death, so it had to have been signed by a representative in a representative capacity, but the authorization did not disclose that. The appellant's counsel would have the court believe that you can look at the packet, the notice packet, to cure defects in the authorization itself. However, that argument has been expressly rejected by this court on at least 2 separate occasions, in JAC versus Methodist, and in the recent case of Hancock versus BJE Enterprises LLC. In both of those cases, there was a failure to describe the authority of the person to sign the release, and the appellant tried to argue that, well, you needed to look to the notice materials because those notice materials would provide the necessary information. That's been rejected. The authorization has to stand on its own. And in this case, you look at the authorization, it does not describe the authority of the person to sign on behalf of Mr. Suttle. And thus you have 2 core elements that are missing here. And the regulations, the HIPAA regulations, are very clear under section 45-CFR 164.508. Pren B provides that if a authorization is incomplete, then it's invalid and it cannot be used. And there would be no way for Dr. Gross to procure any records utilizing this release. Now, Judge Golden, you asked some questions about the other providers, and I think it's a pertinent inquiry that I would like to address because it's a glaring defect in this case. Notice just was not provided to Dr. Gross in Methodist Hospital. This notice letter was sent out to 21 different healthcare providers, and you had 19 providers for whom no authorization was provided whatsoever. That is almost an utter complete failure of the appellant to comply with the statute. The statute ensured that Dr. Gross was entitled to receive complete medical records from all providers receiving a notice letter. It is undisputed that there were 19 providers that received a notice letter for which no HIPAA compliant medical authorization was provided. This is exactly the situation that occurred in the Dolman versus Donovan case. And I submit that under that case, that caused the dismissal of the plaintiff's case as well. In this instance, you have a question about whether or not there was a prejudice to Dr. Gross, and that prejudice, I submit, is clearly evident because the very purpose of Section 121, Pren A, Pren 2, Pren E is to allow providers receiving a notice letter with the means to investigate the allegations of the claim before any lawsuit is filed and mount a defense. And in this instance, Dr. Gross was precluded from exercising those rights, the very rights that the statute was intended to afford. He was denied because of the appellant's failure to comply with the statute. And the cases from this court and the Tennessee Supreme Court are replete that if you have a situation where the defendant or provider is denied the ability to procure the complete medical records of the patient from the other providers, then that's per se that's per se prejudice. And that's the case in this matter because Dr. Gross had no means whatsoever to secure these other records. Remember, he was only involved on the first hospital admission on May 17th, 2014. And all of the other providers were presumably involved in the second hospitalization from May 18th through the date of Mr. Suttle's death on June 14th. Dr. Gross did not know what involvement those people had and had no way of investigating or analyzing any of the claims that the appellant was advocating on behalf of Mr. Suttle's estate. So he was clearly deprived of his rights under the statute, which is prejudice per se, and the trial court correctly concluded that there was no substantial compliance. The plaintiff in no way carried her burden under the Martin versus Rolling Hills case to demonstrate that the defendants did not suffer prejudice as a result of her failure to comply with Tennessee Code Annotated 29-26-121. And she could never meet that burden because I submit that the authorization that was submitted was grossly defective. It left out two core elements, left out a required statement under 508 Paren C2 of the federal regulations, and under HIPAA, the authorization was invalid. Furthermore, she didn't provide 19 other authorizations that were required under the statute. So for those reasons, we respectfully submit.
Did the trial court address the failure of the other recipients that, as you just mentioned, apparently appellant's counsel says trial court didn't really address that? Did the trial court do that?
I don't believe in the order that Dolman is specifically referenced, but the trial court did find that there was a failure to substantially comply with the statute. And I think that that component, the failure to provide 19 authorizations for the other 19 providers, is implicit in her finding that there was not substantial compliance. There's not substantial compliance on two fronts. One, the failure to provide the HIPAA authorization that was compliant with HIPAA for the 19 other providers who received notice, and the failure to provide a HIPAA compliant medical authorization as it relates to the patient's medical records from Methodist Hospital, Your Honor.
Well, what I'm looking at is the order that the trial court entered. It's a little over a page, and it doesn't say anything about that issue.
I agree that it does not reference specifically in relation to the other 19 providers, Your Honor.
All right.
I think that's implicit in the finding of a lack of substantial compliance. But even if that weren't the case, the finding of the trial court relative to the authorization as to Methodist in and of itself was more than sufficient to justify the dismissal of the plaintiff's claim with prejudice, because without complying with the statute, they were not entitled to the 121-day extension of the statute of limitations.
Thank you, Mr. Ryland. You used your time. We'll hear from Mr. Buckner, or Mr. Welford, I'm sorry.
Thank you, Your Honor. Let me address just briefly the points you just raised with Mr. Ryland, because it's true that the court did not get into the effect of the plaintiff failing to give any authorizations whatsoever to either Methodist or Dr. Gross for the other 19 providers. In our case, not even Dr. Gross. We didn't have any record, couldn't explore whether Dr. Gross had any records to give us because no notice was given. So that's 20 authorizations as to Methodist. But as we cited in our brief, this is a pure legal question. There is no factual dispute over this, and the court may affirm a lower court when the lower court has reached the correct decision on different legal grounds than relied upon by the lower court, which by extension would mean on a legal ground that the trial court did not address. We certainly
I'm assuming, y'all, that the appellees argued this to the trial court.
Yes, Your Honor. I was about to say,
okay. All right. I'm sorry.
We repeatedly presented that in our briefs, and so we certainly argued the point. And in fact, as to Methodist, that was our primary argument all along, because this whole issue about Gateway and how to interpret that case is really not relevant to Methodist. It's certainly relevant to Dr. Gross. The Methodist argument has all along been based on the fact that Methodist did not receive any authorizations that enable Methodist to receive records from any other provider. I think that the Martin versus Rolling Hills case seemed to be, to us, the Supreme Court kind of trying to put an exclamation point on a couple of issues that the courts have just repeatedly wrestled with when it comes to how to deal with procedural defects and authorizations. And one of the principles that the court set out, just so there's just no confusion any longer, is that all of the providers named in the notice, not surprisingly, since that's what the statute says, all providers named in the notice are entitled to receive. Now, the statute says complete records. I know the court starting with the Stevens case and all the way through some recent cases at the Court of Appeals level, has sort of interpreted that to mean relevant medical records, but statute says complete. But that's really not before us right now, because Methodist wasn't allowed the right to see whether there were any medical records whatsoever that would have been appropriate here. So it was impossible for Methodist to exercise a benefit that the statute provided to it during the investigative time frame before the lawsuit was filed. That's another important point that several cases have emphasized. They're all cited in our briefs, Dolman being one of them, where the question is not who the plaintiff ultimately decides to sue. The question at the pre-suit notice stage is, at that point in time, there's an investigative function that every provider who's named in the notice is entitled to. And it could be that would lead to some type of consideration of settlement discussions before the lawsuit's filed. So kind of trying to go backwards and analyzing it in terms of, well, I didn't sue all those other providers, and well, they had all the records that they needed anyway, is not the point. The point is, during the investigative period, do all of the providers have the right to explore what relevant medical records may exist with respect to the claim that the plaintiff is raising? The plaintiff, in this case, the appellant, raised an issue on appeal, which the court asked a question as to what matters the trial court considered, and was an argument made to the trial court on the point that I've been addressing the last few minutes. The organized healthcare arrangement argument that appears in the brief, the appellant's brief, was not raised anywhere at the lower court level. It is the appellant's obligation to identify for the court where, if it was argued, it was addressed. The appellants made no effort to do that. And if the court chose to just explore the multi-volume record to look for it, you will not find it, because it is a completely new argument. And so for that reason, and the fact that no factual support by affidavit or otherwise, in this case was resolved by summary judgment, was presented on that point, I won't address that issue any further unless the court has specific questions on it.
I don't think so. Thank you, though. Thank you, counsel, for your argument. We will take this matter under advisement, and we'll endeavor to get you an opinion resolving the issues presented here as quickly as possible. Ms. Tivner, anything we need to take up?
No, Your Honor.
All right, then we will be in recess until the call to the next case.
Thank you.
This honorable court is now in
Thank
recess
you.
until 10 a.m.